Well, Chris, thank you so much for joining us today.
It's great to be here, Edgar. Thanks for having me.
Yeah, so Chris, tell us more about your firm and what you guys do.
Absolutely. So, my name is Chris Bergs. I'm the managing member of Punchwork PLC, and we represent employees all across the United States. I'm speaking to you today from Arkansas, so we have a base here. We particularly have a lot of our clients in lower wage states in the South and Southeast, and it's been a great journey that we're on, and happy to share some of it.
Cool. Thank you so much, Chris. So we're going to talk about today mental health at work, and where good intentions go legally wrong. And the goal is to walk people through some of the common confusion that might occur when someone asks for time off, and also what workers and employers should know about in terms of the legal rights that employees have for time off requests and best practice for employers. And so, Chris, from your experience, what are some of the common confusion or pain points that occur when an employee requests time off from their employer?
Yeah, great question. You use the phrase pain points. I think there's pain all around on this topic.
Yeah,
Pain for the employers, if you're in HR or management, your in-house counsel, but certainly pain for the employees, what they're going through. So, yeah, let's sort through it. I think the biggest thing that people should know is that the incident of mental health, how many people in the workforce have a mental health challenge is a lot higher than most people may realize. I think a long time ago there was a lot of stigma,
hmm,
but from some of the data I've looked at, it's anywhere from 15 to 20% of the workforce at any one point in time is experiencing a mental health challenge. So that's a huge number of people. If you've got 100 people in a company, 15 of them
right,
on any one day are going to have some mental health challenges.
right,
I was looking up some statistics the other day, Edgar, and you talk about mental health is sort of episodic. It
hmm,
can flare up,
right,
and so I looked at a study. It said, on average, just for your average American worker, um, for that 20% that's experiencing a mental illness, 10 days out of the year they're experiencing some pretty severe symptoms.
wow,
So if you think about that, going back to that 100-person company, 15 of those on any one day
hmm,
at work, whether they're remote or in the office, are going to have some pretty severe symptoms. And that's going to impact the job they do, their
right,
coworkers, their family. I mean, I think going back to some of the stigma conversation, you got to realize that as an employer that 15% of your people on any one day are struggling.
right, right.
And that's just a huge thing, and it's not, it's all genders up, just across the board. It's a huge issue, and so I guess the question is, what do we do about it?
Yeah, yeah. And no, I would say that there has been a lot more uh, attention paid to mental health in general and in the workplace. But I do still think that there are some expectations that employers don't quite understand when it comes to addressing mental health in the workplace. Can you talk to that a little bit?
Yeah, absolutely. The expectations, because everybody wants to work at a place where they're valued, right? I
Right,
mean, company owners, obviously, they have their purpose, but I think generally speaking, people want to be treated you know how they would want to be treated,
yeah,
and I think here in the United States, there are federal laws, and
right,
certainly the Family and Medical Leave Act it's a
mhm,
newer law. It's not been around since the 1950s. It's been around since the early 90s. The Americans with Disabilities Act, again, been around for a little bit. It's been amended over the years, but
right,
those are the two big federal laws that you really got to pay attention to as employers of a certain size: the Americans with Disabilities Act, the Family and Medical Leave Act. And again, what happens a lot of times I see, Edgar, is maybe a company starts out smaller.
mhm,
Maybe they have less than 50 employees, and they grow to where they're covered by the FMLA. The FMLA covers businesses with 50 or more employees within 75
right,
miles.
right,
And the ADA, again, maybe they start out small. Maybe they're 5 or 10 people and they get above 15 and 20, and all of a sudden they're covered by the ADA. So those are really the two big ones, the FMLA and the ADA, but
mhm,
they're not easy. They cause those pain points that you
right,
mentioned.
right. And And can you talk to some of the state laws that might apply, and particularly if there might be different expectations in terms of employer size for certain state or local law?
Yeah, absolutely. So if you're a multi-state employer, multi-jurisdictions,
Yeah.
there are a lot of employment laws that you got to pay attention to. So you mentioned, local laws. There are state laws that provide greater protections for
Mm,
employees, and as you and I work in this space, so we know that. But a lot of businesses they really miss that. I was talking to an in-house general counsel. He's the head of HR for a pretty big financial services company.
mhm,
And, he's got to pay attention not only to the federal laws, the ADA and the FMLA that we talked about, the state laws, say, for instance, his office in the state of Washington. But you also have to pay attention to local
right.
ordinances as well. So, city council, county government,
Mhm,
at all levels, those protections exist and they change over time too. And so you've really got to stay on top of it. And I think, speaking generally, a lot of HR professionals, want to. They're trained, but a lot of these laws, intent doesn't necessarily matter sometimes.
right.
So just because you want to stay on top of it, it doesn't mean that your business might not be exposed if you don't actually follow the law.
Right. Right. Well, thank you for that, Chris. And let's dig a little deeper. So let's talk about the ADA and FMLA specifically in terms of what areas they cover when it comes to particularly mental health protections in the workplace, and how they might interplay with one another. And with the idea that also, if you're looking at a state or local hour perspective, would operate the same way.
Yeah, absolutely. I agree. And here's really how they mess it up. And in my experience in policy and private practice,
Yeah.
my law firm, we hear from over 1,000 people a week. So we call that an intake, someone that reaches out to my law firm. And in that experience, here's what I've learned from those 1,000 people a week. Here's how they mess it up. Employers focus more on FMLA.
Mm,
If you're an employer of a certain size, you're focused on FMLA, the Family and Medical Leave Act, which, speaking generally, is 12 weeks of unpaid leave for qualifying employees. If you've been there for a year as an employee or worked 1,250 hours in the past 6 months, so that is how they mess it up. They focus on the FMLA,
yeah.
and when FMLA is up, they advise the company you're free to take an adverse action. But what they don't think about is short-term leave under the ADA
Mm,
is a reasonable accommodation, can be a reasonable accommodation. So, you know, take that company that I mentioned earlier, my friend who works in house there, an employee for that company may have used up 12 weeks of leave. They may have been out because of their condition at FMLA. But if that employee writes in and says, "Hey, can I have a couple more weeks? My surgery recovery didn't go as quickly as possible. Can I have a couple more weeks out? And when I come back, can I maybe work 3/4 time?" That is a request for an ADA accommodation.
hmm
So what employers do, how they mess it up, Edgar, is they get compartmentalized into the FMLA lane and they say, "Oh, FMLA is up. Sorry,
Right.
we don't have your job anymore." And they forget to look at the ADA lane of a short-term accommodation on top of that 12 weeks. It could be reasonable under the ADA. So that's a big thing. You gotta think about all the laws.
Thank you for explaining that, and also um, taking that information and thinking about a real example. Let's say that someone applies for ADA accommodation and it's approved, but an FMLA's leave is denied. What kind of issues do you foresee might be caused because of that?
Yeah, absolutely. So, in your example, FMLA is denied, but maybe they got, short-term accommodation
Yeah.
for the ADA. And it's worth mentioning, the ADA has an extra requirement that's not in Title VII that protects against, race and gender
Mhm.
age discrimination. The ADA has a requirement that the company has to engage in the interactive process. So, when
Mhm.
an employee requests an accommodation, a reasonable accommodation, the company can't just ignore it. They have to engage in that. And I see that all the time. I see even unreasonable requests that are ignored, and that triggers liability. So that's the big thing about the ADA that, Congress wanted to protect people with disabilities or perceived or regarded as having disabilities. And so the companies have to engage. And where they mess it up is oftentimes the large companies will have different departments deal with FMLA or ADA.
Mm-hmm.
You
Hmm.
know, you'll have like a leave department, or they're outsourced to a third party benefits company. And so if the right hand doesn't know what the left hand is doing, so
Right.
to speak,
Right.
at a company, if you're not coordinated, that creates liability. I mean, I have cases all the time where it's the same facts, Edgar, the same person, the same issue, and they go to one person and they get denied, and then they go to another person in the company and they get accepted. And so, which is it? And it goes sort of back, I think, a little bit to the stigma. A lot of what I see is, um, if you have say you don't have a limb, something
Right.
a visible disability to the sort of just layperson's eye, non-medical. If you see someone with a physical disability, that's easier to understand. But when you get into the world of mental health, which
Right.
affect major life activities, I think you still see a little bit of the stigma of like, oh, is this person, are they
Hmm.
really
Right.
manic
Right.
depressive? Do they really have a bipolar disorder? Are we really going to treat that the same as if they lost a limb? And
Hmm.
the ADA says you have to.
Right.
It doesn't matter if it's a lost limb or, manic depression diagnoses, you still are entitled to a reasonable accommodation.
Yeah. And I think to your point about the silos and having different departments doing different things, um, would you say that there is service to anytime you get this type of request, whether it's an ADA accommodation request or FMLA request, that the employer does a uh, takes a holistic approach around making sure that they're providing as many opportunities as possible to the employee to take advantage of the different laws that might apply to them. So that way to avoid um, pain points or employee harm or even a potential lawsuit.
Yeah, absolutely. That's a great point about being holistic, and really from an HR standpoint. If you're looking at it from a business perspective about mitigating risk,
Hmm.
you don't want to end up with that lawsuit that you
Right.
mentioned. That I think I've been involved in 770 lawsuits. I looked the other day. It's a lot of lawsuits in the last
Yeah.
15 years, and those have a cost, and you don't want that. And I don't want that either. Like
Yeah.
I don't want my client to have hired a law firm. I want them to have a manager that supports them, that helps them. So a lot of this, I think, goes back to being holistic, like you talked about, but training. If you have a good manager, a good
Hmm.
relationship with people in the workforce, and you talk about things like this, you talk
Hmm.
about, hey, I might need a day off for to go deal with my child that's having surgery, or I need time off to process the grief that has turned into diagnosed anxiety, all of those things. If
Right.
you're training for that and you have good managers, then a lot of these legal issues go away. But if you don't put in the time to support people and train them, you end up with these cultures really that
Right.
become very litigious.
Yeah. No, that's a very, very good point. And so, taking our scenario, what practical advice do you have for workers in that situation?
Absolutely. Over communicate. That's number one. So
Yeah.
if you're a worker, you're an employee, and I'll say this, Edgar, I was looking at some data the other day. There's some specific sectors that have it's just harder. So take for
Right.
instance, like food service or elder care, retail. If you work in that industry, the incidence of mental health challenges and the need for accommodation goes way up. It just
Mm.
goes way up.
Mhm.
And so, your average retail worker in the United States, your average food service worker, elder care worker, you're going to go through something. I mean, it's a hard job. You're going to go through some stuff. I mean, the data shows that. And so
Yeah.
over communicate, tell your employer what you're going through. Because the ADA really is a strong law. It requires them to
Right.
talk to you back.
Right.
And here's the thing I see a lot. You get what I call the doctor's note problem here. So you get this problem where somebody, an employer, employee is well meaning, and they go to the doctor and they give a doctor's note back.
Right.
And so then the question is, if the company is doing a holistic approach, they'll delve into it. But really, if you're an employee, over communicate, and then when you send in the doctor's note, provide some context with that.
Mhm.
Don't just send in the note. put in some context, say, hey, here's a note. Can I have these days off? Ask, and you don't have to use magic words. You don't have to use the
Yeah.
word ADA or the word
Mhm.
FMLA, but if you can just add some context to your doctor's note and say what's going on with you, that is really going to protect you because it's going to put your employer on notice of what's going on with you.
Yeah. And I would just even add, if, to the extent that there are any HR forms that you should use, do that as well. So that way there is no confusion or wonderment as to like what you're requesting. And a common uh, question I get from a lot of employees is, do I have to list the diagnoses? What if it's something that's very sensitive, or I don't feel comfortable like naming what the issue is, but I just want to explain what the symptoms are, or what happens when I have a flare up of some sort. Is that okay?
Yeah, there's a lot of considerations that go into it. And
Yeah.
so, an employee, you might be nervous, you might not
Right.
be trusting. You've seen what happened to other people,
Right.
and that's normal to feel that way. Particularly if it's a bad workplace. But here's the thing I would say to people: that ADA is such a strong law. I mean,
Mhm.
it requires the employer to talk to you,
Yeah.
and a lot of employees probably know this, but not everybody in the workplace is honest, right? I mean, that's
Yeah.
we wish that that was true, but people are not going to be honest later if a legal issue comes up, in my experience. And
Mhm.
there's I'm not necessarily saying intentionally, but just the because of that, because people might not be honest later. What I mean specifically is people will not tell the truth as
Mhm.
to whether they knew about your issue or not, and so they will say later that they didn't know about it. And if you don't have some kind of documentation proving they know about it, it puts you in a worse spot. So I really encourage people to over communicate and
Yeah.
really provide some context with that the doctor's note that, hey, here's what's going on with me. I know it feels like you're giving away your privacy, but you've got a really strong federal law, the ADA, behind you.
Yeah, and I would just even add there are other federal protections and even state protections, such as the safeguarding of medical information. Commonly people think that it's only medical facilities like hospitals that have to abide by those rules, usually HIPAA. But employers are also subject to HIPAA, and if they violate the law, they can be subject to fines.
Yeah, that's a really good point about
Yeah,
HIPAA. Yeah.
yeah, yeah. Switching to employers, what practical advice do you have for employers in this situation?
Okay. So for employees, my big advice is over communicate, right?
Right.
I don't necessarily think employers, again, I hear from 1,000 people a week about what's going on at jobs, lots of crazy stuff going on at jobs out there.
Yeah.
People are human. But here's the thing I would say about employers: if you're an HR professional or, you're a business owner trying to have a good culture. And this is kind of a little more maybe psychological than legal, Edgar, but I really believe it. Um, Pause is what I would say to
Mhm,
employers.
mhm,
Breathe, calm down, pause, and breathe when you get an employment law issue. Where I see people make mistakes all the time is they make a rush to judgment and
mhm,
they make an emotional decision, right? And so, if you're trying to protect yourself, protect your company, work with your HR in house, whatever the case may be, the number one thing that I see is employers do not pause. Instead, they rush to judgment. And I can speak to this, Edgar. Like, it's frustrating dealing with people sometimes on workplace issues, right?
right, right,
Where
right.
people, humans, we frustrate each other, right? We do things that are not nice to each other. But the answer to that is not to repay them in kind. If
Mhm,
something bad happens, if people make a mistake, the answer to that, I mean, there's got to be consequences. Obviously, I'm not arguing for that. But what I'm saying is, before you make your decision about what you're going to do about HR legal issue, just pause and
mhm,
breathe and make sure you're not making, an irrational decision because
yeah,
um, it's just so unfortunate, Eric, because you have people that have devoted their lives to companies, people that have
right,
poured themselves into it, whose careers have been ended over misunderstandings, over
right.
hurt feelings. Just pause, just breathe, take a holistic look at everything.
That's a great point, and I would echo that sentiment that uh, when making important HR decisions, that really impacting people's lives. Like when we think about mental health, A lot of people don't make those requests, for fun. Usually when it gets to that place, there's something serious happening or something that has to be managed, right? So it's people are in a vulnerable position. We're making these requests a lot of times. So taking that opportunity to sit back, take the request, really think on it, and more importantly, follow the process that the law requires, is will go a long way. Even if ultimately you may not be able to honor the request, you might find another way because you've done the work to really think through all the different avenues that might be available to you.
Absolutely. Yeah, follow the
Yeah,
process.
yeah. Um, so another thing that comes up that employers sometimes wonder about is consistency. And as we all know, not everyone's situation is the same, right? Even if two people are claiming I have bipolar disease, doesn't mean that the accommodation might look the same for each person. So how do employers maintain consistency to ensure that one, they're focused on the person in front of them with the request that they've made, but also not opening themselves up to liability because they're making decisions that might look different from person to person.
Yeah, that's a great question about consistency because, if you're in HR's position or the employer, you're thinking not only about maybe a mental health ADA issue, but you've also got to think about consistency across
Mm.
Title VII. So, what I mean by that is, are you giving people of a different gender, different treatment, or different race, different national origin? You've got to follow your procedures in the federal law in all ways. And so,
Right.
it's not easy. I mean, that's why these jobs
Yeah.
exist, right? That's why there are HR jobs and why there are in-house counsel and that, lawyers, that's why we have roles to play here. But I think that the big thing I would say about consistency in my experience is employers err in the wrong way. And so what I
Hmm.
mean by that is when two people may approach the employer, as you mentioned, instead of denying both in the name of consistency, like, hey, we can't do this in the name of consistency because if we do this, we will have to do this for these other people.
Right.
Y- there it is consistent to grant both, the same as it is consistent to deny both. And
Mm.
so I see some error there, but I think the bigger thing is documenting, a legitimate, non-discriminatory, non-retaliatory reason for the non-performance. And so
Mm.
that's where companies mess it up. Is their story is always this employee wasn't good at their job, they're failing, and we had a legitimate, non-discriminatory, non-retaliatory reason for what we did to the employee, suspension, termination. I mean, if I had a penny for every time I
Mhm.
heard, we had a legitimate reason, then, I'd be giving away a lot of pennies right now. But that is often true. I mean, I'm not going to deny it, but
Yeah.
the times that it's documented, and so that's really a failure of the business culture to document non-performance, and I don't mean it in a punitive way. Like in a good culture, if someone isn't doing a good job, they want to know that in writing too. And people may have different views on human nature and how generous people are, but the bottom line is if your company is not documenting non-performance, you're opening
Right.
yourself up for liability.
Yeah. No. Great points. Thank you, Chris. So, as you mentioned earlier, uh, mental health requests for accommodations or for time off have increased, and it has changed the workplace environment. What is your take on increases in requests for remote work accommodations? That seems to be a new feature with remote work or hybrid work being the preferred way that many employers and employees are working together now. And secondly, are there any ongoing legal gray areas when it comes to ADA FMLA requests, particularly as it relates to mental health?
Absolutely. Oh, two big topics. I agree. You
Yeah,
saved the big ones for the
yeah,
end.
yeah,
On the first one on remote work, I'm talking to you sort of post the big COVID surge, in 2026, which is not to say that COVID has gone away totally.
right,
It's still there, but we're in 2026 right now, and remote work. I'll use a phrase. It's tricky. There's a song lyric out there. It's tricky. Like this is a tricky issue. It's tricky. And so what I mean by that is there are often legitimate business reasons to change remote work policies. But where I see people messing up recently is just because company may have allowed remote work during COVID and is now changing the policy, it doesn't mean that the company must enforce the policy absolutely with no exceptions. I mean, the ADA still exists, even though a company may have switched to fully in person or remote. You still, if your policy goes to 100% in person and you get an ADA request to work remote, you still have to evaluate that. You can't
Right.
ignore that. You can't just say, "Hey, we got a policy to be back in the office now." The ADA still applies. And by the way, all the other federal laws still
Right.
apply.
Right.
The
Right.
protections against religious discrimination and
Right.
racial discrimination. So just because you change your policy to say, "Hey, we used to be, remote during COVID, you got to be in office now," you still got to engage in reasonable
Right.
accommodations, and you got to take that holistic approach that you asked about. And on your second question, Edgar, I mean, that's again, the statistics on mental health are just staggering if for
Mhm.
people that haven't looked into them. I mean, 15%, 15 out of 100 people at every company in the United States today are experiencing, diagnosed anxiety, depression, impacting their work performance. And the question for employers is, hey, if you have like a quota system, like if you're in sales or something, are there sales down for a little bit because of this mental health issue?
Right.
And it's just so many companies mess that up, Edgar. I got a quick story for you. I promise
Yeah.
it'll be quick,
No.
but
No, please.
it's not confidential. It's all public. But I had a client was the sweetest, hardest working lady, and she had some mental health challenges after some physical health challenges,
Okay.
and her coworkers actually took up like a donation for her to help her with some of her mental health care. She was in a tough situation, and the company, rather than acknowledging her request for a little bit of leeway in her numbers, actually raised her numbers. They raised her quota, so to speak,
Wow.
because of this request, and it was so outrageous, not only to her, but also to coworkers. It ended up resolving, but it's just, it tells you that there are people out there that do not understand that the mental health is covered by the ADA, and it's something that you do this work to help raise that awareness, and I appreciate you doing that.
Yeah, no problem. Um, any final key takeaways, Chris?
I'd say this, that you're in the world of employment law, it is tricky, it's complicated. And I mentioned some of the statistics for what I do. My firm does pre-litigation, litigation,
Yeah.
and employment law. But I would say, roughly speaking, about a third of everything we do could have been resolved with a conversation if people would just talk to each other.
Yeah.
And that's I'm not saying that selfishly. I mean, that would be a third of the business that I would lose and my law firm would lose, and a third less people work here. I'm not intentionally trying to put my firm out of business here, but what I'm saying is, if people would just talk to each other, then there'd be a lot less lawsuits, a lot less lost jobs, a lot
Right.
more understanding. And it just, I think the stigma from mental health and the ADA, there'd be a lot more understanding. So I encourage everybody, just talk to your boss, put it in writing. If you're in HR, just talk to them. Please just talk to everybody.
Yeah, no, that's some very salient advice. I would agree. I would say that a lot of times when people feel they have no other choice, they go to a lawyer, and the lawyer
Right.
has to, help figure out what happened, and a lot of times you're not resolving a legal claim, you're resolving hurt feelings and bad communication, so that's a very good point. And the one thing I would add is that, particularly in this area, workers have a lot more rights than they would think. Even if you work in a smaller employer, you still might have state or local level laws that might protect you. So I just would encourage workers to always be mindful of what their legal protections are, preferably before you start making requests. So that way you have a better understanding as what the process should look like, and be able to advocate for yourself along the way. Um, and just know that Workplace Fairness has resources um, on ADA and FMLA and all the different laws around the country that would apply, and how to advocate for yourself. So I would encourage everyone to visit www.workplacefairness.org for those resources. Chris, any resources you want to share, particularly your law firm website or anything else?
Yeah, I mean, thank you for doing the work that you do, Edgar.
Yeah.
Definitely go to your website, Workers Fairness. I mean, great, an amazing resource, a lot of information. And yeah, I would just echo what you said. Like, if you're a worker, you're an employee, knowledge is power. I mean, just
Yeah.
there's a lot of resources out there. Workers Fairness is a great one. The EEOC has its own website, eeoc.gov. It's got some information, but and I would say too, in addition to knowledge being power, your employer, there's a phrase, "Power concedes nothing without a demand." So the employer is kind of in control, right? They're the employer,
Yeah.
but they're not going to concede. They're not going to give you anything if you don't ask.
Right.
Power concedes nothing without a demand. So I'm not suggesting go in there and demand your own parking space. What I am suggesting is talk to your employer about your issue.
Yeah.
Ask them for something because the law requires that they respond to you.
Yeah. Well, Chris, thank you so much. And we'll be back.